Greetings, my fellow freedom lovers and sovereign thinkers. Thank you for tuning in to LO3 Podcast. My name is Craig, transmitting from the beautiful swampy mangrove South Florida. Oh, actually, the beautiful land of enchantment. So used to talking about South Florida here. And today's date is Friday, April 17th, 2020. Yep, so looks like a couple things going to be happening. Not happening, but some horrific events that occurred around this time, including April 19th. Waco, Oklahoma City, even during the week, shootings that happened at Virginia Tech, etc. But something to think about. However, there's some people's birthdays out there. If it's on that time, wish you happy birthday as well. So I'm going to be talking about a couple things here. It's interesting and good and bad. But this one here came from the Rutherford Institute. Came out today. It says here, appeals court chills First Amendment activity by allowing cops to retaliate against non-violent protesters. So, as it reads here, Rutherford Institute is pushing back against an effort by police to chill constitutionally protected civil rights protest through the use of retaliatory lawsuits. In filing an infamous curiae brief in the U.S. Supreme Court in Mckesson versus Doe, Rutherford Institute attorneys are challenging a ruling by the Fifth Circuit Court of Appeals that allows law enforcement officials to protest organizers financially liable when officers get hurt, accidental or otherwise, while carrying out their duties at a constitutionally protected demonstration, even when the organizers themselves did nothing to cause injury. Incredibly, the lower court reasoned that organizers of a protest should be responsible for engaging in activity that merely has the potential to involve police or require their presence, thereby exposing them to possible injuries. The case arose after a police officer positioned a near group that was protesting police brutality in front of police headquarters was hit by a projectile thrown by an unknown, unidentified individual. The injured officer sued one of the event organizers, D. Mckesson, for more than $75,000, despite the fact that Mckesson engaged in no acts of violence and did not incite or condone violence by others. So what they're saying is Mr. Mckesson is being scapegoated. So we're going to continue on here. Attorneys Aaron Glenn Busby, Lisa R. Esco, and Michael F. Sterling of the University of Texas School of Law Supreme Court Clinic assist in advancing the legal arguments in Mckesson. Police have mastered the art of the double standard. They don't want to be held accountable for their own misconduct or that of their fellow officers, but they want to throw the book at anyone who peacefully engages in constitutionally protected activities if that person is nearby when a cop gets hurt on the job. The constitutional attorney John W. Whitehead, president of the Rutherford Institute and author of Battlefield America, The War on the American People. This is yet another Machiavellian attempt by the government to prevent Americans from exercising their First Amendment right to peacefully speak truth to power. In July 2016, activists took the streets in outrage after two Baton Rouge police officers who shot 37-year-old Alton Sterling 6 times at close range while the man was pinned to the ground. The incident, which was recorded by bystanders and shared on social media, sparked outrage in the city's African American community. On July 9th, activists demonstrated in front of the Baton Rouge Police Department's headquarters to protest the escalating police violence directed at black men and women nationwide and demand accountability and reforms. During the protest, D. Ray Mckesson one of the event organizers, engaged in no acts of violence and did not incite or condone violence by others. While demonstrating began peacefully, enraged protesters began throwing objects at police who were massed nearby preparing to make arrests. One officer was struck and injured by a rock thrown by an unknown protester. The injured officer brought a personal injury lawsuit against Meckelson and the Black Lives Matter movement, seeking more than $75,000, claiming they knew or should have known that violence would erupt during a demonstration. But if police officers do it, it's called exceptionalism. And don't get me wrong, I'm not anti-police or anything like that, but you're always going to have those rogue elements like everywhere else, including what happened with this demonstration. But we'll continue on here. The lawsuit was dismissed by the trial court, which ruled that Meckelson engaged in constitutionally protected activity and there was no allegation that he had authorized or directed any violent actions. On appeal, the Fifth Circuit Court of Appeals reinstated the lawsuit, ruling that Meckelson could be liable for officers' injuries because Meckelson should have known police might respond to the protest, inciting violence by protesters. In this brief, Rutherford Institute warns against allowing police to weaponize personal injury lawsuits in order to chill First Amendment activities. And it's interesting about this because how come it went to a federal level but not on the state level? That's the question I have for the police officer. What do they call him? John Doe in this one? I believe so. So it's very disturbing. And don't be surprised if this person can be a hired fool dressed up as a protester in disguise and say, hey, pay me and I will do the job. That could be another rogue element, possibly by the city of Baton Rouge or anyone else. We don't know that. But the whole thing is this. It's called a witch hunting game. Let's blame the one person for everyone else's, for someone else's stupidity because they were there. Assuming is okay. So you see this double speak? Abraham Lincoln will get his rocks off on this. Exceptionalism. And what was really disturbing because when you examine this, because they're not, he's actually, how I look at it, I'm seeing the so-called due process of law on this lawsuit that they actually depriving Mr. Meckenson's life and liberty and property, okay? And he is a human being, and he did everything by the book, and it's all in good faith. You're gonna blame someone? You're gonna blame another person for someone else's problem? It's like, hey, you see how these anti-gunners are going to want to go blame the NRA or Donald Trump for for horrific events at some of the school shootings. Okay, that's what it is. It's the same thing, folks. No ands, ifs, or buts. So it's saying that you can chill your freedom of expression under Article 1, Section 7 of their state constitution. No law shall curtail or restrain the freedom of speech or the press. Every person may speak, write, and publish his sentiments on any subject, but is responsible for abuse of that freedom. That's for that abuse, not someone else's. All right? And, of course, on Section 9, on the Louisiana's Declaration of Rights, no law shall impair the right of any person to assemble peacefully or to petition the government for a redress of grievances. As long as he's doing things peacefully, that's fine. You go after the aggressor, not the organizer. As long as Mr. Meckelson did not say start a riot. He says he believes in nonviolence, according to the amicus brief, and everyone honored it. But we're going to have a few knuckleheads or hired thugs making a burden on everyone. And I'm not, condemning like it's horrible what happened to a Baton Rouge officer who got injured, but you don't go around taking on that other person. He's not their babysitter. Like it says here about enumerated rights, enumeration in this Constitution of certain rights shall not be denied or disparage other rights retained by the individual citizens of the state. As Section 24 of the state's Declaration of Rights, Article 1. So I'm going to leave that up there, and you can give me your intake. And I just do find it pretty disturbing, because what's going to happen? It's the blame game, okay? That's what this officer is doing. And what really intrigues me in his brief, John Doe, according to his brief, his name is John Doe. I don't know if that's Officer John Doe. That doesn't make any sense, but it is very disturbing indeed. And what's good about this amicus brief, it does talk about the history of nonviolent protest and so forth, and the free speech, okay, First Amendment, which that's important. And that's why I have to question, how come it went on a federal level? It should have stayed in the state of Louisiana. So I have to disagree on what that happened. So I'm just giving you a summary version of this argument, all right, on this amicus brief, which is a link to this. Like it says here, protect speech has shaped American democracy throughout the nation's history. And I love these guys, but please do not use the term democracy. That's sacrilege. And I'm a member of this organization, and I say that in good love and in good faith, okay? And to preserve the breathing space required to ensure freedom of speech, this court has placed stringent limitations on criminal and civil laws that directly restrict or indirectly chill speech on matters of public concern. Those limitations are most needed and most strictly imposed when speech criticizes the government. The Fifth Circuit's negligent protest tort strikes at the core of protected speech, yet it includes none of the special protections this court's First Amendment jurisprudence requires. Instead, it creates a vast exposure to civil liability in circumstances that will be present whenever protesters collectively occupy public spaces. The trigger for the negligent protest tort is a predicate criminal act by the organizer, and protest by nature often involve unlawful conduct. So disobedience is a hallmark of a historical and contemporary protest involve violating the law to call attention to the law's injustice, or as happened below, a protest may unlawfully block a highway. The petition app 11A to 12A, in either scenario, once the predicated unlawful act occurs, protest organizers face liability not only for their own unlawful conduct, but for any foreseeable damage occurring during the protest. Regardless who is injured and who causes the injury, that sweeping exposure will inhere in almost any group protest and will affect speakers across the political spectrum, from civil rights to pro-life activists to negligent protest tort, thus cannot be reconciled with the special protections the First Amendment demands and this court's jurisprudence requires when a law threatens to chill core protected speech. So that's a summarized version. You can read the rest of it. The link is on this page. And I just hope the Supreme Court will understand. But the whole thing is this. The state of Louisiana got those rights on the Declaration of Rights. So, I don't know what Mr. Doe has to say, but you know what? I have to say this. You go after the perpetrator, the assailant, not the innocent bystander, because scapegoating is unacceptable. So, we're going to do one more here. I'm making these a little bit pretty brief. And this one came from the consortiumnews.com. And talk about COVID-19, progress seen in talks to end Yemen war, which a lot of us haven't really heard talk about that in the news lately, but I've been keeping tabs on this horrific event. And people out there should be protesting on the United States, U.S. government, including the Trump administration, on this matter. All right, so of all the other garbage and nitpicking, this is bigger, thicker, okay, bigger than that. Remember, United States foreign policy is very meek for a very long time, and that includes during the Trump administration. It doesn't matter, Democrat or Republican. It's been very consistently bad. So it says here, and who wrote this? One moment, I believe who wrote this. It is written by Joe Loria, and it says here the UN envoy came out today, by the way. The UN envoy to Yemen has told UN Security Council he expects the Saudi-led coalition and the houses to agree in the immediate future on a package of proposals intended to end the 5-year-old war in Yemen. And you know what, my friends? I do have to agree on that. So, on that. Martin Griffiths told Council on Thursday that he has been in consistent negotiations with the parties over the past 2 weeks on his proposal. These include a nationwide ceasefire agreement, humanitarian and economic measures, and urgent resumption for talks of a political settlement. Griffiths told the council in a virtual meeting, "I can report that we are making very good progress. We're moving towards a consensus over a proposal, particularly on the principle of a nationwide ceasefire, and we are redoubling our efforts to bridge the outstanding differences between parties before we convene them at a meeting where, because it was virtual agreements would be tabled, confirmed, and published." Griffiths said the humanitarian measures include releases of prisoners and detainees, opening Sana's International Airport, paying civil servant salaries, opening access roads, and ensuring the entry of ships carrying essential commodities into the Hodeidah ports. The latter would mean lifting the Saudi blockade, a move that would demonstrate that Riyadh is serious about its unilateral ceasefire declared on April 8th, which is like that. The Saudi move was spurred by a fear of the pandemic, which had already taken 150 members of the Saudi royal family, numbered at around 15,000. Governor Riyadh was among those stricken. There was no case of COVID-19 in Yemen when the Saudis announced this unilateral ceasefire and its intention to end the war. Since then, there has been one reported infection in the country, which remains unsolved. But based on the conditions in Yemen, we don't know how many people actually being affected. So there cannot be more timely a moment for the two parties to commit to silencing the guns and ending the conflict through a peaceful political solution, Griffith says. Yemen cannot face two fronts at the same time, a war and a pandemic. The new battle that Yemen faces in confronting the virus will be all-consuming. We can do no less than stop this war and turn to our attention to this new threat. Griffiths praised his parties. Griffiths said he was grateful to both parties for the way in which they have conducted their negotiations with the United Nations, open, constructive, and focused. He singled out the Houthi leader for his intentions to bring the hostilities to a close. In my discussion with Mr. Abdel Malik al-Houthi, he has always communicated a desire to end this war, he said. The UN envoy said a diplomatic consensus to end the war is playing a crucial and indeed central role in pushing all of us and both parties toward what we hope will be a successful conclusion in the near term. Crucially, the United States is backing the ceasefire as well as peace negotiations. Good. I'm very pleased to hear that. All right, I'm very firm on that. So, and I'll say this too about this whole, like even Barack Obama sent equipment to Saudi Arabia as well. So It's not just on President Trump, but the Obama administration as well. Remember, traditional, consistent, lousy foreign policy. So Griffith said despite intangible progress, the fighting continued, but he did not think it would derail the negotiations, as many skeptics say. Lamentably, military activities continue on a number of fronts despite many calls from Yemenis and the international community in his council for it to top. He said, I fear it will continue until we get an agreement on proposals, including nationwide ceasefire. I say end the war in Yemen now. So, what do I have to say about it? End the damn war. Period. Because here's the thing. Yemen is one of the most poorest countries in the Middle East. When I heard about this 5 years ago, I like, what the hell? And some people thought it was okay. No, it's not. As a ceasefire, the United States said they support it. Make it happen. I'm not a big fan of the United Nations, but when it comes to something like this, yeah, it has to be done. That nation needs a lot of support. They rebuild their lives. There's still beautiful people in that country. And what happened, to me is unacceptable. Alright? Like beating someone when they're down. Now look what happened with the royalties getting COVID-19. It took them this long. It's a shame, but you know what? It's about time. End the war in Yemen. Now. And including everyone else in the Middle East and the world. And that is it. I thank everyone for listening. Plus, feel free to download and share us on social media networks. If you have questions, comments, let me send something that's interesting you want to check out. Whatever you do, please send your correspondence with decorum. Furthermore, I'll leave all the footnotes of this episode on my Spreaker page. Once again, thank you for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves, keep on spreading love, and may your guardian spirits be with you.